Donald Trump is accused of inciting violence against the government. Specifically this, the storming of Congress by thousands of his supporters. But his accusers say you have to go back a couple of months to last November's presidential election.
We know there was massive fraud.
That was a rigged election.
If you count the legal votes, I easily win.
Trump lost, but refused to admit it. Not only that, but when the state of Georgia was getting ready to hold a second round of voting to settle two very close Senate races, Mr. Trump is accused of trying to intervene illegally.
I only need 11,000 votes. Fellas, I need 11,000 votes. Give me a break.
It all came to a head on January the 6th, when Congress was due to confirm the results of the presidential election. In a long, bitter speech, Mr. Trump railed against the entire election process.
We fight like hell, and if you don't fight like hell, you're not going to have a country anymore.
Within minutes of him finishing, some of his supporters were breaking into the Capitol building.
Okay, so the courts just delivered a massive 1-2 punch to Trump's agenda that has Capitol Hill absolutely erupting right now. We're talking about federal judges in two different states simultaneously blocking Trump from slapping new political conditions on more than $350 million in Homeland Security grants to cities and counties across the country. And at the same time, 21 Democratic-led states just launched a major lawsuit to stop Trump's administration from cutting food assistance to lawful immigrants, people who are here legally, who followed the rules, who did everything right, and now they're being told they can't get food aid because Trump wants to punish immigrant communities. This is wild. Trump has been trying to weaponize federal money using grants and food assistance as leverage to force cities and states to comply with his culture war demands. And judges are finally saying, no, you can't do that. That's not how federal law works, and we're shutting it down. The political explosion on Capitol Hill is real because these rulings expose exactly how far Trump has been willing to go to use federal resources as a weapon against communities he doesn't like. But before we go any further, real quick, let's be honest, you can't really trust headlines anymore. That's why we built Pump Politics to bring you real stories, real context, and no corporate spin. If you want to stay ahead of the headlines, join our free newsletter. We'll send the news straight to your inbox every day. Just click the link in the description to join. And if you just want to support what we're doing, join us, be part of the community that actually cares about the truth. All right, let's get back to the video.
America's First Amendment, which protects freedom of speech, gives Mr. Trump lots of leeway to say pretty much whatever he wants, short of ordering his supporters to storm the Capitol, which he did not do.
I know that everyone here will soon be marching over to the Capitol building to peacefully and patriotically make your voices heard.
It'll be up to the Senate's 100 members to decide if Mr. Trump is guilty or not, and the Democrats will need at least 17 Republicans to join them to get a conviction. It's a really tall order. Most Republicans think the trial shouldn't even be happening.
Let me break down what happened with the grants, because this is a huge deal for cities across the country. On November 21st, two federal judges, Judge William Orrick in California and Judge Manny Shaw in Chicago, issued separate injunctions blocking the Trump administration from imposing new conditions on DHS grants. These are emergency preparedness grants that cities and counties use to hire emergency personnel, fund disaster response, and prepare for major events. We're talking about the kind of money communities need to keep people safe during hurricanes, earthquakes, terrorist attacks, and massive public gatherings like the Super Bowl and the World Cup. And Trump's team decided to make this money conditional on a bunch of culture war demands requirements about immigration enforcement, diversity policies, and other things that have nothing to do with emergency preparedness. The judges looked at this and said absolutely not. They found the administration likely violated federal law by tying emergency funds to these political demands. You can't just take money that Congress appropriated for one purpose and make cities jump through political hoops to get it. That's not how appropriations work. That's not how federalism works. And judges are shutting it down. The scale of what's at stake here is enormous. The plaintiff cities and counties in these cases represent about 30 million people. That's not a small number. That's the population of some countries, and they're fighting over more than $350 million in grants that they need for public safety. These communities were told that money they've been counting on, money they'd already budgeted for, already made hiring decisions based on, was suddenly going to come with strings attached that had nothing to do with the actual purpose of the grants. Imagine you're a fire department that's been told you'll get federal money to hire new firefighters. You start the hiring process, you make offers, and then the federal government says, actually, we're going to withhold that money unless your city does whatever we demand on immigration policy. That's what Trump was trying to do. And judges in California and Chicago, appointed by different presidents, operating in different circuits, both independently concluded it's probably illegal. But wait, It gets worse for the administration because the SNAP lawsuit is equally devastating. On November 25th and 26th, right around Thanksgiving, when millions of families are thinking about food, a coalition of 21 Democratic-led states in Washington, D.C. sued the USDA over new guidance that cuts off food benefits for lawful permanent residents. These aren't undocumented immigrants. These are people who are here legally, including former refugees and asylees who came to America fleeing persecution and were granted legal status. The Trump administration issued guidance saying these people shouldn't get SNAP benefits, and states are now facing an impossible choice: either wrongly terminate aid for people who are legally entitled to it or face crushing financial penalties from the federal government. New York Attorney General Letitia James and California Attorney General Rob Bonta filed separate complaints calling this policy unlawful and cruel, and they pointed out that states are still recovering from the whiplash of Trump's earlier attempt to block November SNAP payments during the government shutdown. It's one attack on food assistance after another. First trying to slash payments during the shutdown, now trying to cut off lawful immigrants entirely. The pattern here is unmistakable. Trump is trying to use federal money as a weapon to punish communities and populations he doesn't like. Cities that have sanctuary policies cut their emergency grants. Immigrants who are here legally cut their food assistance. States that don't do exactly what he demands threaten them with financial penalties. This isn't governing. This is extortion dressed up in bureaucratic language. And judges are finally stepping in to say there are limits. You can't just take appropriated funds and attach whatever political conditions you want to them. And you can't reinterpret eligibility rules to cut off people who are legally entitled to benefits. So buckle up, because we're about to dive into exactly what these judges found, why the grant conditions are likely illegal, what the SNAP lawsuit alleges, and what all of this means for Trump's strategy of weaponizing federal resources against communities he wants to punish. Let's break it down. All right, so let's get into the specifics of what these federal judges found, because the rulings are absolutely devastating for Trump's strategy of using grant money as political leverage. The two cases, one in California before Judge William Orrick and one in Chicago before Judge Manish Shah, both challenged the administration's decision to impose new conditions on DHS preparedness grants. These are grants from the Federal Emergency Management Agency that go to state and local governments to help them prepare for emergencies, disasters, and major public events. The money is supposed to be used for things like training first responders, buying emergency equipment, developing evacuation plans, and coordinating with federal agencies during crises. Congress appropriated this money for emergency preparedness, not for immigration enforcement or culture war battles. But Trump's team decided to attach conditions that had nothing to do with the actual purpose of the grants. The conditions the administration tried to impose included requirements related to immigration enforcement, cooperation, diversity and equity policies, and other politically charged demands. Cities and counties that wanted their emergency preparedness money would have to certify compliance with these conditions, even though the conditions had nothing to do with emergency preparedness. It was a classic bait and switch. Congress says, here's money for disaster response. Cities plan their budgets around receiving that money. And then the executive branch says, actually, you can only have this money if you do what we want on completely unrelated policy issues. That's not how the appropriations process is supposed to work. Congress decides what federal money gets spent on. The executive branch administers those programs according to congressional intent. The president can't just invent new conditions that Congress never authorized and use them to advance his political agenda. Both judges found that the administration likely violated the law by imposing these conditions. The legal theory is straightforward. When Congress appropriates money for a specific purpose, the executive branch has to spend it for that purpose. They can't add conditions that transform the nature of the grant into something Congress didn't authorize. If Congress wanted to tie emergency preparedness funding to immigration enforcement, Congress could have done that. They didn't. So the administration can't just make that choice on its own and impose it on cities and counties that are trying to access funds they're entitled to. The judges issued preliminary injunctions blocking the new conditions, meaning the administration can't enforce them while the cases proceed. Cities and counties can access their emergency preparedness money without having to comply with the political demands Trump's team tried to attach. The practical impact of these conditions would have been severe for public safety. The plaintiff cities and counties use these grants for critical emergency functions. We're talking about hiring emergency managers and first responders. We're talking about funding disaster response coordination centers. We're talking about preparing for major events that require massive security operations. The World Cup is coming, the Super Bowl happens every year, and these events require extensive planning and resources that cities partly fund through federal grants. If those grants get held up because of fights over immigration policy or diversity requirements, the events don't get postponed. They happen anyway, with less preparation and fewer resources. The same goes for natural disasters. Hurricanes and earthquakes don't wait for court cases to resolve. Communities need their emergency preparedness money now. not whenever Trump's team decides they've sufficiently complied with political demands that have nothing to do with keeping people safe. Now let's talk about the SNAP lawsuit, because this is equally significant and arguably even more cruel in its immediate human impact. The Supplemental Nutrition Assistance Program, food stamps, helps low-income families afford groceries. It's a lifeline for millions of Americans who would otherwise struggle to put food on the table. Eligibility for SNAP is determined by a complex set of rules that include income requirements, work requirements, and immigration status rules. Lawful permanent residents, people with green cards who are here legally, are generally eligible for SNAP after meeting certain residency requirements. Former refugees and asylees who were granted legal status are also eligible. These aren't people trying to game the system. These are people who follow the rules, obtain legal status, and are entitled to the same safety net benefits as other eligible Americans. The Trump administration issued new guidance that reinterprets the eligibility rules in ways that would cut off SNAP benefits for thousands of these lawful permanent residents. The guidance tells states to apply the rules more restrictively, to terminate benefits for people who were previously eligible. And here's the trap states are facing. If they follow the new guidance and wrongly terminate benefits, they're hurting people who are legally entitled to food assistance. But if they don't follow the guidance and keep providing benefits according to the previous interpretation, the federal government will penalize them financially. States are stuck between doing the right thing and facing federal punishment, or doing the wrong thing and hurting vulnerable people. That's not how cooperative federalism is supposed to work. That's coercion dressed up as guidance. The coalition of 21 states plus Washington, D.C. that filed suit is arguing that the new guidance is unlawful, that it misreads the statute and improperly restricts eligibility in ways Congress never authorized. New York Attorney General Letitia James and California Attorney General Rob Bonta filed separate complaints making similar arguments. They're all saying the same thing. The Trump administration is twisting the rules to cut off food assistance for people who are legally entitled to it, and courts need to step in and stop it. The timing is particularly cruel. The lawsuits were filed right around Thanksgiving, when Americans are focused on food and family and gratitude. And the Trump administration is trying to take food away from lawful immigrants and their children during the holiday season. The attorneys general use words like unlawful and cruel to describe the policy. They're not mincing words because the policy doesn't deserve polite language. The connection to the earlier SNAP fight during the shutdown adds context to what's happening. Just weeks ago, Trump's administration tried to slash November SNAP payments during the government shutdown, paying only 65% of what recipients were owed. Federal judges blocked that, ordering full payment. Now the administration is back with a different attack on the same program. Instead of cutting payment amounts, they're trying to cut off entire categories of recipients. It's one assault on food assistance after another. States describe themselves as still recovering from the whiplash of the earlier fight. When this new attack landed, they barely finished fighting to protect SNAP payments during the shutdown, and now they have to fight to protect SNAP eligibility for lawful immigrants. The administration seems determined to find ways to cut food assistance, no matter how many times courts stop them. The broader pattern of using federal money as a weapon against disfavored communities is now impossible to ignore. The grant conditions for cities tie emergency preparedness money to immigration and culture war demands. The SNAP guidance cuts food benefits for immigrant communities. The shutdown payment cuts targeted low-income families across the board. In each case, the administration is taking money that Congress appropriated for specific purposes and either attaching political conditions to it or restricting eligibility in ways that punish populations Trump wants to hurt. It's a systematic effort to weaponize federal resources, to use the power of the purse not for legitimate policy goals, but for political retribution against cities, states, and communities that don't support Trump's agenda. And courts are systematically pushing back, finding these efforts unlawful over and over again. The legal theories judges are using to block these policies share common threads. When Congress appropriates money, the executive branch has to spend it according to congressional intent. The president can't add conditions Congress didn't authorize. The administration can't reinterpret eligibility rules to cut off people who were previously entitled to benefits without going through proper rulemaking processes. There are limits on executive power, even when it comes to spending decisions. The president isn't a king who can do whatever he wants with federal money. There are laws, procedures, and constitutional constraints, and judges are enforcing them against an administration that seems to believe those limits don't apply to them. Each ruling adds to the growing body of precedent that Trump's approach to federal spending is legally problematic, which makes future challenges easier to win. Okay, let's break this down into clear points so you understand exactly what happened and why it matters so much. Point number 1, on November 21st, federal judges in California and Chicago issued separate injunctions blocking the Trump administration from imposing new political conditions on more than $350 million in DHS emergency preparedness grants to cities and counties. The judges found the administration likely violated federal law by tying emergency funds to immigration, diversity, and other culture war demands that have nothing to do with the actual purpose of the grants. Congress appropriated this money for emergency preparedness. The administration can't just attach whatever political conditions it wants and make cities jump through hoops to access funds they're entitled to. The injunctions protect communities representing about 30 million people and ensure they can get their emergency preparedness money without complying with demands that have nothing to do with keeping people safe. Point number 2. On November 25th and 26th, a coalition of 21 Democratic-led states in Washington, D.C. sued the USDA over new guidance that unlawfully cuts off SNAP food benefits for thousands of lawful permanent residents, including former refugees and asylees. These are people who are here legally, they follow the rules, obtain legal status, and are entitled to food assistance under existing law. The Trump administration issued guidance reinterpreting eligibility rules to exclude them. States face an impossible choice: either wrongly terminate benefits for people who are entitled to them, or face financial penalties from the federal government for not following the new guidance. This is coercion dressed up as administrative guidance. Point number 3. New York Attorney General Letitia James and California Attorney General Rob Bonta filed separate complaints calling the SNAP policy unlawful and cruel, and noted that states are still recovering from the whiplash of Trump's earlier attempt to slash SNAP payments during the government shutdown. This is the second major attack on food assistance in just weeks. First, the administration tried to cut payment amounts during the shutdown. When courts blocked that, they pivoted to cutting eligibility for immigrant communities. It's one assault on food assistance after another, with the administration seemingly determined to find ways to cut benefits no matter how many times courts stopped them. Point number 4. These rulings fit a pattern of Trump trying to weaponize federal money as a tool for political retribution against cities, states, and communities he doesn't like. Sanctuary cities face conditions on their emergency grants. Immigrant communities face cuts to their food benefits. Low-income families face reduced payments during the shutdown. In each case, the administration is taking money Congress appropriated and either attaching political strings or restricting access in ways designed to punish disfavored populations. This isn't legitimate policy disagreement, it's using the power of the purse as a weapon against political enemies. Point number 5. Courts are systematically pushing back and finding these efforts unlawful, creating a body of precedent that limits the administration's ability to weaponize federal spending. Each ruling makes the next challenge easier because judges can cite previous findings that the administration has exceeded its legal authority. The pattern of judicial defeats is establishing that there are real limits on executive power over spending. The president can't just do whatever he wants with federal money, and courts will enforce the constraints that exist in law and the Constitution. Now let's talk about what this means for the broader fight over Trump's use of federal resources as political weapons, because these rulings have implications that extend far beyond just these specific cases. The grant conditions and SNAP guidance are just the most visible examples of a systematic approach to governance that treats federal money as a tool for reward and punishment rather than as resources that should be distributed according to law. Cities that cooperate with Trump's agenda get their grants. Cities that don't face conditions designed to punish them. Communities that Trump likes get their benefits. Communities he doesn't like face eligibility restrictions designed to cut them off. This isn't how federal programs are supposed to work. They're supposed to operate according to consistent rules that apply equally to everyone, not according to the political preferences of whoever happens to be president. The practical consequences for affected communities are severe and immediate. Cities and counties that were counting on emergency preparedness grants had to scramble when the administration tried to impose new conditions. They didn't know if they'd get their money. They couldn't complete hiring they'd planned. They faced uncertainty about whether they could adequately prepare for disasters and major events. The injunctions restore some stability, but the uncertainty itself caused harm. Similarly, SNAP recipients who are lawful permanent residents are now facing the prospect of losing food benefits they depend on. Even if the lawsuits ultimately succeed, the anxiety and uncertainty cause real harm to real people who don't know if they'll be able to feed their families next month. For states, the SNAP fight creates an impossible situation that illustrates how the administration is trying to coerce compliance with policies that may be unlawful. States administer SNAP using a combination of federal funds and state resources. When the federal government issues guidance about eligibility, states have to decide whether to follow it. If the guidance is wrong, if it misreads the law and will cut off people who are actually entitled to benefits, states face a dilemma. Follow the guidance and hurt people wrongly. Reject the guidance and face financial penalties. The lawsuits are an attempt to get courts to resolve this dilemma by declaring the guidance unlawful before states have to make impossible choices. The political implications for 2026 are significant because these fights feed into narratives both parties are trying to build Democrats will argue that Trump's policies are cruel, chaotic, and illegal, that he's trying to take food away from legal immigrants and withhold emergency money from cities to punish them for political disagreements. They can point to multiple court rulings finding the administration likely broke the law. Republicans will try to frame these as legitimate policy disputes about immigration and federal spending, but it's hard to explain why emergency preparedness grants should come with conditions about diversity policies or why lawful permanent residents should lose food benefits. The cruelty of timing SNAP cuts right before Thanksgiving, the chaos of cities not knowing if they'll get emergency funds, these are politically damaging images that will feature in campaign ads and debate talking points. The systematic nature of judicial pushback is itself becoming a story. It's not just one judge ruling against one policy. It's multiple judges across multiple circuits, appointed by different presidents, independently reaching similar conclusions that the Trump administration is exceeding its legal authority in how it handles federal money and benefits. Each ruling adds weight to the next. Each finding of likely illegality makes it easier for the next court to reach similar conclusions. The administration is building a track record of losses that demonstrates their approach has fundamental legal problems. And that track record will constrain what they can do going forward, because courts will be more skeptical of similar attempts and more willing to issue injunctions based on the pattern of past behavior. Here's the bottom line. Federal judges just delivered a devastating 1-2 punch to Trump's strategy of weaponizing federal money against communities he doesn't like. Two separate courts blocked the administration from imposing political conditions on more than $350 million in emergency preparedness grants to cities and counties, finding they likely violated federal law, and 21 Democratic-led states sued to stop SNAP cuts targeting lawful permanent residents, with attorneys general calling the policy unlawful and cruel. These rulings expose a pattern of using federal resources as tools for political retribution rather than administering programs according to law. Courts are systematically pushing back and establishing that there are limits on what the administration can do with appropriated funds. So stay tuned, because these legal fights are just getting started. The grant cases and SNAP lawsuits will continue through the courts. More challenges to similar policies will follow, and the accumulating judicial defeats will constrain what the administration can do while also providing ammunition for political attacks heading into 2026. Trump thought he could use federal money as a weapon without consequences, threatening cities, punishing immigrant communities, cutting food assistance whenever he wanted. Judges are saying no, the law matters. Appropriations have to be spent according to congressional intent. Eligibility rules can't be rewritten to exclude people who are entitled to benefits. The president isn't a king who can do whatever he wants with the public's money. And every time courts enforce those limits, it becomes clear that Trump's approach to governance isn't just cruel and chaotic, it's fundamentally incompatible with how the American legal system is supposed to work. The courts are checking executive overreach. The question now is whether the administration will learn from these defeats or keep pushing until they run into even harder limits. Based on everything we've seen, they're probably going to keep pushing, and courts are probably going to keep stopping them. Pay attention, because this fight over federal money and who controls it is one of the central battles of Trump's second term, and right now, the courts are winning.